What happens when a simple noise complaint just completely spirals out of control? Well, sometimes it goes all the way to the Supreme Court of Canada and ends up redefining the line between your privacy and police powers. So today, let's break down how a late night argument over loud music totally changed the rules for everyone. So let's just run through the timeline real quick. It all kicks off with a call about loud music in Halifax way back on December 28th, 2009. The police show up, things get tense at the door, a gun suddenly appears, and boom, almost 5 years later, the highest court in the country has to step in to sort it all out. All right, so here's how we're going to break this whole thing down. We'll start right at the beginning with that noise complaint. Then we'll zero in on that critical moment at the doorway. We'll look at why the lower courts just couldn't agree, and then we're going to unpack the two massive legal questions that the Supreme Court had to answer. All of which, by the way, led to a brand new rule for police interactions right at your front door.
Okay, so let's set the scene. It's the evening of December 28th, 2009. We're in a Halifax condo. Mr. MacDonald has his music cranked up, and yeah, his neighbors are really not having it.
So first up, the building's concierge tries to get him to turn it down. No dice. Mr. MacDonald swears at him and refuses. So then a police officer arrives. She knocks on the door, and she gets the exact same treatment. More swearing and a door slammed in her face. Okay, so this is clearly not a simple noise complaint anymore, so she does the right thing and calls her supervisor for backup.
And this, right here, is where everything changes. The supervisor, Sergeant Boyd, shows up. He knocks, he even kicks the door and yells, "Halifax Regional Police," trying to get Mr. MacDonald to come out. This one moment, right at the threshold of that apartment, is what sparks the entire legal firestorm.
So Mr. MacDonald finally opens the door, but just a crack, maybe 16 inches. And Sergeant Boyd, he immediately spots something black and shiny in MacDonald's hand, kind of hidden behind his leg. He asks him twice, "What do you have behind your leg?" And what does he get back? Nothing, just silence.
So you've got this tense standoff. The officer is faced with silence and a potential threat, so he makes a split-second decision. He pushes the door open just a few more inches, just enough to get a better look. And this tiny movement, this little nudge on the door, becomes the single most important action in this entire case. And that little bit of extra light reveals exactly what Mr. MacDonald was hiding: a loaded 9mm Beretta handgun. The officer yells "gun," he rushes in, and after a short struggle, he gets him disarmed. And just like that, the noise complaint has turned into a major firearms incident. Now, you might be thinking, this is an open and shut case, right? But believe me, the legal journey was anything but simple. In fact, before this thing even got near the Supreme Court, two different lower courts looked at the exact same set of facts and came to completely different conclusions. The entire case really boiled down to two huge questions. First, was that little push on the door an illegal search? Did it violate his privacy rights? And second, what about the gun? I mean, if Mr. MacDonald honestly thought his gun license was valid, does that mistake of law actually excuse the crime? And you can see right here how divided the courts were. The first trial court said, yep, the search was legal and he's guilty on all counts. Simple. But then it goes to the Court of Appeal, and while they agreed the search was fine, they did something really fascinating. They acquitted him on the gun charge. They said it was an honest mistake. And this kind of fundamental disagreement is exactly why the Supreme Court had to step in and give a final answer. Okay, so let's tackle that first big question, the search. This is a classic constitutional dilemma, right? It pits your fundamental right to privacy in your own home against the very real need for police to make sure they're safe. At the heart of all of this is Section 8 of the Canadian Charter of Rights and Freedoms. It's the part that protects all of us from unreasonable search or seizure. And the courts have said time and time again that this protection is at its absolute peak when we're talking about someone's home. Your home is basically a fortress in the eyes of the law. So, first things first, did the officer's push on the door even count as a search? The Supreme Court came back with a crystal clear answer: yes, absolutely. You see, the police have what's called an implied license to walk up to your door and knock. But the second Sergeant Boyd pushed that door open, even a little, he crossed a constitutional line. It officially became a search, and that means all of Section 8's protections kicked right in. But hold on. Just because it was a search doesn't automatically mean it was an unreasonable one. To figure that out, the court uses this three-part test. Think of it like a checklist. First, was the action even allowed by some law? Second, is that law itself fair and constitutional? And third, was the search actually carried out in a reasonable way? You have to be able to check all three of those boxes. And this is where it gets really interesting, because you can see the debate that was happening inside the court itself. All the judges agreed a safety search could be justified, but they argued over the standard. The majority set a really high bar. Police have to have reasonable grounds to believe there's an imminent threat. But a smaller group of judges thought the standard should be lower, just reasonable grounds to suspect a threat. And trust me, the difference between believe and suspect in the legal world is massive. So where did the court land? They ruled the search was legal. And why? Because in this specific, tense situation, with the hidden object in MacDonald's total silence, Sergeant Boyd's actions met even that higher standard. He had reasonable grounds to believe his safety was in immediate danger. Okay, so the search was legal. That means the gun evidence is fair game. But that just brings us to the second huge legal question, the gun license itself. Remember, Mr. MacDonald genuinely believed his Alberta license was perfectly fine in Nova Scotia. The Court of Appeal bought that argument, called it an honest mistake, and let him off. But is that really how the law works? Well, the law makes a really critical distinction here between a mistake of fact and a mistake of law. A mistake of fact is like, thinking a bag of sugar is actually flour and accidentally baking with it. That can be a valid defense. But a mistake of law, like not knowing the rules about your gun license being valid across provinces, that's a whole different ballgame. And there's a very simple reason for that. It's one of the oldest principles in our entire legal system, and it's written right there in Section 19 of the Criminal Code. Ignorance of the law is no excuse. Plain and simple. You are expected to know the laws that apply to what you're doing. So, based on that long-standing principle, the Supreme Court's decision was pretty straightforward. They overturned the Court of Appeal's acquittal. They said Mr. MacDonald's mistaken belief about his license was a mistake of law, not a mistake of fact. And with that, his conviction for illegal possession of that loaded, restricted firearm was put right back in place. So, wow, after all of that legal wrangling, what does this all mean for us? Well, the R.V. MacDonald case basically created a new, clear set of rules for what can happen at the threshold of your home. So here it is, the new doorstep rule in a nutshell. Police can search your doorway without a warrant if their safety is at risk. But, and this is a huge but, they have to have a reasonable belief that there is an immediate threat, not just a vague suspicion. And the search has to be as minimal as possible, only what's needed to deal with that threat. And finally, the court made it absolutely clear. Not knowing the law is never going to be a valid defense. In the end, this whole case was about finding a balance between two really important values: the sanctity of your private home versus the safety of police officers. The Supreme Court drew a new line in the sand, giving officers a very limited power to cross your threshold if they reasonably believe their life is in danger. So the question this leaves us with is, if it were your door and your privacy on the line, do you think they drew that line in the right place?